Okay, hi, my name's Lori Hagan, and I work here at the Allegheny County Law Library. I'm the reference librarian, or one of them, should I say. I'm also the outreach and CLE person, so I try to put these programs or get speakers in to talk about different topics. If you have a topic you want to share and would like to do a CLE with us, you're welcome to do so. I think I have everybody's on the list on the roster through the Pennsylvania CLE board. So the only thing I would need is if to get CLE credits for this, if you are an active member of Allegheny County Law Library, it is $10 today. If you are not, it's $25. So, and you can always give me a call at 412-350-5353 is our main number, but it's closest to our credit card machine, so I can process it that way, or you can send us a check. So my email address, in case you need it, is Hagen, Hagenl @duq.edu. And at this point, I'm going to turn this over to John Eunice, Esquire, from Bit by Bit.
Thanks, Lori. Good afternoon, everybody. Excited to be talking today about how attorneys and non-attorneys can leverage technology to solve e-discovery challenges. It's a pretty broad topic. I'm going to sort of cover a lot in the next hour or so. So as I go through the content, if you have any questions while I'm speaking, just use the chat and I'll monitor that chat bubble and break apart the conversation here to address your questions. And at the end, if you'd rather wait at the end as well, that's fine too. A bit about myself, as Lori mentioned, I'm an attorney. I was in private practice for 10 years, mostly at Jones Day. I'm a Pitt Law alum. And then I was in-house counsel for Bayer Corp and Covestro, a Bayer spinoff, for the next 10 years of my career. And then 2 years ago, a week before the global pandemic started, I became general counsel of Bit by Bit. So I left a large international company for a small one. It was interesting, a transition time in my career, but it's worked out great. I'm still our company's lawyer and became CEO of the firm in December 2020. So I wear 5 or 6 hats. A lawyer is one of them, and teaching things about e-discovery is a big part of what I do for the firm. We've been based in Pittsburgh since 2007, have a mix of attorneys and non-attorneys that help lawyers and organizations through e-discovery, forensic, and cybersecurity challenges. So we're going to talk about today the EDRM workflow. That's the electronic discovery reference model. That's sort of the end-to-end macro level overview about e-discovery in the life cycle of data through investigations and litigation. Then we're going to take a little deeper dive into data mapping, which is sort of step 1 of that process. What does your client have? Where does it reside? And how do you collect it defensively? Once you do collect the data sources, the next step in that process is getting that data ready for attorney review. And that's our third topic, which is data processing, which is the use of technology and other processes to winnow down those data sets to a more manageable level and to hone in on more relevant information earlier on in the process. We'll then highlight review platforms, what those can do for lawyers. Long gone are the days, and I did this in my private practice years, where you'd sit in the warehouse with a box of documents and tape flags, and you would color code the documents from, red is responsive and blue is not, and green is privileged. Technology can do all that for you these days. And then we're going to talk about advanced analytics. So this technology within review platforms has increased greatly in even the past 10 years. There are algorithms now within many platforms to help attorneys find information faster, more efficiently, and even without the need to review every document in a file set. That might give some lawyers pause. Even some of our clients today in 2022 say, no, wait a minute, does that mean I don't have to look at every file before I produce a data set? And the answer is yes. So we'll talk about the technology as well as what's in courts have had to say about blessing that technology and giving the attorneys the green light to use analytics to help speed review and optimize the workflows and ultimately save costs. So step 1, the big picture overview of the EDRM workflow is on your screen. This is the updated version. There are many iterations of this chart, but essentially for today's purposes, we're going to start with that red rectangle, which is helping your client identify what might be responsive or relevant for your particular case or investigation. Once you do identify the potential corpus of data, step 2 is then preserving and or collecting that information. And that can mean different things, but it's one thing to know where the data is and what it is, which is that red box. and then going and getting it, which are the purple boxes. So we'll talk about each of these in more detail as we walk through the process. Step 3 then is when there's actually a time in the work in the litigation or investigation process to actually give the adversary, the government, whoever it might be, some subset of what you've collected and preserved. That's where the processing and review comes in, which are those blue boxes about halfway through the slide there. And then using analytics to analyze what you have as a piece of it in many cases, especially for larger data sets. And then finally producing that information to the other side, which is, I guess, that teal looking box. The far right is the presentation box for like presenting at trial or in a hearing or something or in court. But our focus today is going to be on the identification of what's important, the red box, going out and collecting it in a defensible way, the purple boxes, and using technology to go through that to winnow down the set and review it and then make sure the other side gets what's necessary and nothing more. I'll give you a little framework of where the different workflows fall into place. And it's sort of like a funnel. So the very left side, the volume is going to be a lot greater. And all the way to the right side, the relevance is a much smaller data set. And all those middle boxes help the attorney find and narrow down what really needs to be produced to the other side and what can be withheld. So understanding this process, it might sound very technical, but it's a mix of legal and technical acumen here. So attorneys do need to stay on top of electronic stored information or ESI topics. Many ethical rules, like Pennsylvania, for example, there's duty of technical competence, meaning that if you have a case that involves technology or electronic data, you need to understand what's out there and how you can get through that information to collect and find it in a defensible manner. The rules go so far as to say, if you don't understand technology, when there's a need in the case, you either decline the representation, hire somebody that understands it to help you through it, or learn it. So this is an overview of how this might not seem germane to your practice, but as the world becomes more and more digital, it will be important. We have cases, for example, ranging from a family law dispute for a cell phone all the way up to mass torts where you're going through terabytes of data and millions of pages of files to produce to an adversary. So it really is broad reaching. And not speaking on one half of the bar or the other, we're also seeing an increase in litigation about discovery. So enterprising plaintiffs attorneys use these rules as a hook and an anchor to put pressure on the defendant, where they understand that if you can't find things appropriately or preserve it defensively and evidence gets lost, they can craft a spoliation argument, destructive evidence charge. So it does behoove lawyers to understand at least the basics of these things and call for help when and if needed. But it really is about planning. It's no longer just the IT person's responsibility. The lawyers really have to have a sense of how these things can impact the case and the strategy. Using the federal rules as a guidepost, Rule 26, for example, does have proportionality put into it that was strengthened in 2017. So it's not like a fishing expedition where you have to produce everything to the adversary. There's a cost-benefit analysis to be had there. We'll talk about this later in the presentation. That's where technology can come in and help you. So for an example, if you have 1 million emails to go through in a 3-month period, and you're pretty sure a lot of that stuff is irrelevant, you don't want to spend time and attorney hours reviewing every single email file in that example, the tech can help you get through that much more quickly and even help you avoid reviewing some of the junk. So that's where Rule 26 comes into play, doing what's proportional to the needs of the case, a lot of the cost of going through the information. But the very first step of that is data mapping, getting your hands around what's out there to begin with. That's where the first step in this process to see what the corpus is, and then going through the other steps of the process, which we'll get to later. So what is a data map and why is it so important for lawyers to understand that? Here's some examples from the records management discipline of repositories for corporations where, and I've seen many forms of this, these are just some samples, and we can talk to you about this, of course, if needed, where the lawyer in partnership with IT, maybe HR, if it's a labor employment case, maybe it's a CIO, maybe it's the maybe it's a litigation attorney, sits down with their client. There's no magic button to this, but it's more of like a mini deposition, an interview, understanding what systems or repositories do corporate records reside in. Here in this sample example, there's SharePoint, network drives, maybe old legacy systems that might have information in them still that no longer in use, but still have information residing in them. The next step is, okay, who owns those systems or who can access them? So you know where the corporate records are, which is that first column. And the next step of the process is, okay, who uses that information? Who has access to it? Who in the company can modify the information, delete the information, exfiltrate the information, and change it? So that's sort of the next step in the process. Who can share the information? Who in the company has the ability to transmit the data to one another? And what document types are there? So these are just some examples of forms that we've seen, we've used clients map through where it might seem like a very technical or very non-legal discussion. But believe me, 6 months down the road, if these discussions aren't had, you're trying to find information when maybe things are deleted or moved or systems are changed, you're going to have a much harder time explaining to the court why these discussions were had earlier in the process. Another example, I apologize if it's kind of gritty on your screen. It's not great on my screen either. But here's an example of a system that a company uses to sort of record all the information about certain corporate records. So as an example here, you've got the record type or title, maybe it's finance and accounting, the record description, records related to banking and cash. And then even within that, there is a delineation on why the record has to be kept and for how long. So it might be a tax record that needs to be retained for 7 years because of certain IRS regulations. You might have OSHA records for employees that need to be retained for 30 years after the employee separation date. Maybe if you work for a chemical company like I used to, you want to maintain your chemical formulas forever because that's important patent information you want to maintain. So it's really an iterative discussion where it's a combination of disciplines. It's legal in conjunction with a subject matter expert. Maybe it's a scientist in a business unit, or maybe it's a doctor if it's a healthcare organization, or maybe it's the records manager or the IT person. But it's a holistic approach to understanding what's out there, how long should you keep it and why, what's defensible based on the regulations, and then developing a structure around that. I oversaw a process like this at Bayer when I was in-house, and it wasn't easy. Now, it's a large corporation, 100,000 employees. It took a couple of years to get through it, so it's not a quick fix. But believe it or not, the company had been in existence for 120 years, founded in Germany in the Americas in the early 1900s, and it never went through the exercise. So you'd think large organizations have all this figured out, and not all of them do. So it's good to understand that and ask those questions up front when you start representing a client or an engagement happens. So let's drill down one more level. So I walked through a few minutes there about the ways in which you can record the information and what are the key kind of macro details to recover. Now we're going to talk about the most common data sources that are collected from that might contain information relevant for recovery and analysis. In most cases, personal computers the employees use, mobile devices, whether they're company issued or personal in nature with company information on them, cloud storage locations, corporate networks, external hard drives, and then social media locations are all common areas where corporate data resides, whether there's a policy around it or not. A lot of times the client will say, well, people aren't allowed to use thumb drives. But is it technically feasible for them to do so? If there's a corporate policy saying you shouldn't use a thumb drive to take work home in the evenings, if the PCs aren't disabled, if the ports aren't disabled, I can tell you this from experience, 9 times out of 10, there's going to be data on thumb drives, even though the policy says that you shouldn't be doing it. So asking those questions and going that next level, even if there's a written policy about it, if there's not a technical prohibition to using these sorts of sources to store company information, you should ask at least about these, if not others. So we'll walk through the next few slides, some common watchouts about how to collect this information, and then we'll move on to processing and review next. So PCs. A lot of people think a computer just has their Word documents, their what are called user files, the PowerPoints, the Excel files, and that's all true. But what isn't always known is what's on a forensic image of that computer. So a lot of times what we get called upon to assess is the data underneath the data that a typical user can see that's extractable using forensic software. It's similar software that the government uses, the FBI and the DOJ. It's kind of like CSI, but for real life, where you get a forensic copy of the hard drive. And there's a wealth of information that might not be relevant in every case, but some cases it might be, that's available to attorneys to assess. For example, deleted content. A lot of times when a user sends a file to the recycle bin and hits delete, it's not truly gone until it's overwritten by other data. It will sit in what's called unallocated space on that hard drive. And so a lot of times we're asked to figure out, well, there's a file here that was important. It's no longer there. Can you recover it for us? And many times you can. There is also metadata on the computer about what files and folders were accessed by the user. So while the file might not be there, you might be able to discern that on X date and X time, he or she was accessing something on the corporate network they shouldn't have been, perhaps, as an example, or accessing it from a computer's third-party software or a cloud location of the internet. So there are traces of the activity like that on a computer's hard drive that can be recovered to explain what was being interacted with, what was being accessed and searched for. If you want to know whether or not thumb drives are plugged into a PC, that's often recorded. Whenever a thumb drive is plugged in, there's a little bit of code written on the metadata that will tell the user on X date and Y time a thumb drive with this serial number was plugged in. And that might be important to your investigation. If the user, for example, was accessing a corporate network and then 5 minutes later putting in a thumb drive, that's pretty good evidence that might be taking something outside the company when they shouldn't have been, as an example. But all these things are dependent on the make and model of the computer. Windows PCs are a little different than Macs. They both store things in a different way for different periods of time. And so at a high level overview, these are some artifacts that are typically recovered, but it really truly is dependent on how they use the computer and what model they used. The next common source would be company issued mobile devices. So if you work for a large company, even a small one, you might get a phone to do company work. And then sometimes the IT department will put mobile device management on those devices. One common watch out there is a lot of attorneys think that, well, MDM will help me then get back the emails and data I care about. And that's not really the purpose of that software. What that really does, it's a security tool that's put on there to sort of limit the information that could be on the company's network and associated with the company environment. It doesn't really help with collection of data. And actually, in many cases, it impinges the ability to get data off the phone. So what often happens is if there's a corporate device with MDM installed, we have to work with IT to take off the MDM software to then extract the data from the phone. So there are common sources like text messages, of course, deleted texts, Safari searches, social media activity that's often cached on the databases on the phone. The user might delete something, think it's gone, but sometimes it really isn't gone. Another thing there, dichotomy there would be iPhones or Androids. There are different things to watch out there for as well. So it's one thing to know they have a smartphone for use, but what kind of smartphone? And it differs for a few various reasons. The most common reason is how to collect data off of the phone. So with iPhones, there are certain ways in which expert can actually collect the phone remotely. You can have the iPhone backed up to iCloud and do forensic capture of the iCloud backup. You can have the phone backed up to iTunes and then ship a drive to the person, the custodian, and then collect the iTunes backup. Those methods aren't available for Androids. In addition, the way in which Androids are architected, there are so many steps you have to take to do a remote collection of an Android, buttons and settings and toggle switches that we don't even mess with that because it's really fraught with error. So whenever there's an Android phone at issue, those need to be in our hands typically to collect, where the iPhone has some additional options that can be collected remotely. If your client has data in a cloud storage location, so it might not be company sanctioned where the employee is not supposed to have information in their personal Dropbox or the Google Drive, but through interviews, you'll learn they did, running late one day, they forwarded a file home, worked on it from home. They are recoverable. As long as you have the administrative credentials to that account, there's forensic software that could be had to pull down that data from the cloud source. A common watch out there, though, is because they're so easy to get data into, there's a lot of extraneous data in those cloud locations. It takes a long time to get data out of them. So we have seen cases where there's hundreds of gigabytes in the cloud location. It might take weeks of computer time, just machine time to pull the data out, where it's uploads very quick. So that's a common to watch out as well. That's why a lot of companies actually put the technical prohibition, or at least the written prohibition, using the cloud to have company data in it, because if that's where the data is stored, sometimes it's really hard to get it back out of it. Business class accounts a little different. Those are really designed for corporate use. And so sometimes we can get information either more easily, but if there's a personal cloud account, that's where the real problems come in, getting data out of it for corporate purposes. But these are all parts of the interview recommended lawyers have with their clients doing the mapping process. So ask that second question. The first question is, do you permit, as a policy standpoint, the use of the cloud, for example, or personal phones? And the second question is there technical ability to do so regardless of the policy? And then you ask the custodian about that, just to cover all of your bases. Corporate networks, these are often considered systems of record. So that might be something on a company's server or a private cloud, an operations drive. It's called different things in different organizations, but you can learn about the structure of the networks. Some of them have automated deletion cycles built in. For example, there could be certain networks where when you upload a file, after 2 years, the file gets deleted for purposes of record retention. It's good to know that up front, because if you're running up against that deletion cycle and need a preservation obligation for litigation case, you better get that out of there before the cycle automatically deletes the file. So these sort of questions to ask your client as you're interviewing them about their corporate networks. Is there automated deletion built in? How are they structured? Who has access to those files? The next location in our data map journey would be external USB drives or hard drives. So as I mentioned before, there might be a policy prohibition, but whether or not there's a technical prohibition is a different story. There's interesting strategy involved here as well. We've had many cases where we know, based on a forensic image of a computer, that someone plugged a thumb drive in at a specific day and time down to the second. And so the lawyer has to decide, do I want to be proactive about that and tell the former employee, for example, we know you took something, we know you plugged something in, give us that drive back. The other way to approach that would be, we believe or suspect that a thumb drive is plugged in. Please send back what you plugged in. You'd be surprised at people sending back thumb drives that weren't the one that was plugged in. They don't think we have the metadata available to cross-check on that, and they dig themselves a deeper hole. So they think that, well, I'll send a thumb drive back that's kind of innocuous, and I'll get out of jail free. But the metadata on the hard drive that we image will tell us exactly what's plugged in down to the serial number, and we can sort of use that as a strategy point as well. And then finally, in our data mapping journey, social media and messaging apps. This has definitely been an explosion in the last couple of years, certainly in COVID with Teams exploding, WhatsApp, Slack. There are purpose-built tools designed to collect these sources in particular. For example, ONA is a common tool that companies like us use for Slack collections. X1 is a tool we use for often Facebook, Instagram, and LinkedIn. There's a tool called 4IG that can collect all those tools. We like it for Salesforce. A lot of our clients have Salesforce chatter data, a big part of their data source they need to collect. And so 4IG can build connectors to Salesforce. Now, Microsoft has tools as well to collect Teams and email, of course. All these tools aren't foolproof. So while there are tools designed to collect these sources, the constant struggle is the developers of the apps and the social media content constantly update their algorithms and their back end for security purposes and for good reasons. But that means that the tools built to collect those sources are playing catch up a lot. So while yes, these are all gettable content and can be retrieved, don't be surprised if you come to collect something and it's not exactly what you're looking for, or it's not a full data set. Maybe it's a partial collection, because the collection tools have to play catch up with the APIs that the developers constantly change. But they are out there. So I'll pause. So our EDM workflow, we talked about the identification piece. So sitting with your client, identifying what are the potential repositories of information out there. That's sort of the data mapping and the chart we talked about. We then walk through how to defensively collect those sources. Now in the life cycle, we are at the middle phase of my chart, where now it's time to collect the data and we don't have any yet to review it. We want to get ready for review. And you have hundreds and hundreds of gigs, maybe terabytes of data. What do I do with it? I can't possibly look at all that information. Can technology help me narrow down that data set? And the answer is yes. So once you collect the client's data, there's a few important things to keep in mind about how to get it ready for a training review or professional review. In the data processing stage, a couple things to keep in mind. You might have 100 gigabytes of data, but often those data sets expand when they're processed, meaning you might have a zip file from a computer that was collected. When you load that data into a processing tool, it gets unzipped. And so all the emails or attachments or PDFs or spreadsheets that were in that zip then open up, and they have to be looked at by the tool as well. Metadata gets extracted as well. So that's information about the files. But what you need to do then is take a look at the data set and figure out, how can I narrow this a little bit? And there's some common ways to do that. So the most common way is called deduplication or near deduplication. And what that means is you might collect 10 PCs from a bunch of company employees. They might have the same file on the computer 10 times. That's not necessary to look at 10 times. And so if it's a true duplicate, that can be removed in the process. Maybe you have an email thread and you collect, again, just using rough numbers, 10 custodial email accounts out of Outlook. And they're all in the same thread. You might want to keep the most inclusive email and not all the different parts of the chain that lead up to that most inclusive email. That can be done with technology. So you're looking at actually just the most inclusive of those sets. You can find near duplicates. Say, for example, you have Word documents and there are versions and red lines and drafts, but you really care about the final contract, for example, and not necessarily all the red lines or maybe the last few modifications. The tools can help you find what the near duplicates are, and you can winnow those out as well before you actually look at them. We're talking about computers, for example. That's where the denisting process comes in. So NIST is an acronym, it's here on the screen, for National Institute of Standards and Technology. What the tools can do is then pull out of the processing set what I call our junk files. They're basically system files and log files that are on a computer that do weigh down the data set, but they don't have anything for lawyers to look at. So it'll actually exclude, once you process them, remove from the data set these NIST files. And so at the end of the day, you are left with things that actually you can apply key terms to in date filters, which is my last pillar there. So you can have a conversation with your expert about, okay, what are the key dates in this investigation or litigation? Are there key terms or phrases I really care about? Often these are negotiated with the other side. Sometimes they're not. It's the lawyer's judgment to look at their data set in a defensible, responsible way. But the use of all of these processes, deduplication or near deduping, denisting, key term searching, date filtering, in our experience, for every 10 gigabytes that's ingested, basically 2 come out on the other end for review. So you can really narrow down what you're dealing with in review workspace if you have a proactive approach to processing and have a fulsome discussion about what's really important and what settings you care most about. Any questions about that piece? I'm watching the chat as well in case you do have them. Okay, excellent. Okay, so now we're on our journey. To recap briefly, we identified what's important. We went and collected it in a defensible way. We processed that data. How do I go about looking at the information to decide whether or not it's responsive, it needs to be produced, maybe it's privileged and shouldn't be produced? And that's where review platforms come in. There are really 2 big picture models out there in the market today for eDiscovery. There are sort of full service end-to-end support model, and there's what I call a self-service model, and there's key differences in each one. So the full service model will be something like a bit by bit as an example, where you would hire a firm to help you winnow the data set down. They would host the data in a platform for you, and you would log into their system and review it and tag for what's important. So the support provider would create coding fields for you to look at. Maybe you have responsiveness tag, a non-responsive tag, a privilege tag, a hot document tag. It could be very malleable. They would help you then structure the review and even use analytics, which we'll get to in a few minutes. And then you then identify the documents, what's important. You can then tag what needs to be produced, and the vendor will then help you do that. The other model is really self-service model, where it's all on the actual attorney to drag and drop a data file into their own system and do the processing on their own. No problem, Don. Thanks for the note. So here, you don't have an outside support. It's basically a cloud-based system where the attorney can drag and drop a file into the system and it gets self-processed, uploaded for review, but there's no project management support. It's all on the lawyer or the paralegal to do the work his or herself. So that could be better for some cases and not for other cases, but there's really no, unless you really know the system, there's no way to have outside folks or to customize the fields or to run analytics in it. So it's possible for that to be a right situation for you, or the full service model might be a way to go. It just depends on your case needs. Excuse me, back on the clicker here. Great. Some examples of technology out there in the market. Relativity is a pretty commonly known platform. There are others, many others as well. Reveal is a common platform. Insight's another one. There's a lot out there. Relativity is what we mostly use. And then within those technologies, there are built-on analytics tools and functions. A few you see here on the screen. I'll talk about them for a minute and then move over to the actual review. But Blackout is a tool that can identify with some training things like social security numbers, birth dates, things personal in nature, and it can automatically redact that information. Maybe it's attorney-client communications. You redact it before it's produced. It can help you do that in an automated fashion and saves a lot of time. H5 Matter Analytics and BrainSpace are sort of what's called continuous active learning tools, where if you have a set of concepts that you think are important, you can review the documents, you can teach the software what's important to you, that helps find more information like that based on the remaining data set that's out there that you haven't yet reviewed. So these are all tools that you can use to organize the corpus I mentioned earlier and go through it faster, be more efficient, and spend less attorney time looking at either extraneous files or doing more manual labor like redacting documents or putting blackout tags on documents. So I'll focus now, shifting towards analytics, to advanced analytics or advanced algorithms, and walk through a couple of use cases and then some court decisions on how this technology can be used by attorneys. So here's some examples, just a color wheel, and I'll walk through these a little bit of types of analytics. Big picture, there are structural analytics and conceptual analytics, and there are tools in each of those buckets. The structural analytics help you organize data in a relational way. Think of email threads that need to be put together. Maybe you have a bunch of emails from different conversations that you want threaded together in one conversation. The other type of analytics will help you identify concepts and key terms and phrases, organize the data in a graphical way to help you figure out how the data relates to one another from a term or phrase standpoint. So kind of big picture, those are examples of analytical functions, and here's some tools on the screen within each subset. So relativity analytics has what's called concept searching and clustering to help do prioritized review. What that means is, and there's an example on the screen here, before you even look at a data set, you can put that data into the tool. This is an example of a dummy data set from the Hillary Clinton investigations in 2016. You see on the screen the Podesta email, and this is available to suppliers to look at. So what you do is you feed the data into the system. Without looking at a single file, the system then studies the nomenclature and the taxonomy and the documents in the data set and helps categorize the most common conversations and threads. So here you see, for example, campaign, McCain, and ad, campaign, Senate, Congress, McCain, American economy, that blue wheel. Those are overlapping pretty common concepts. And the size of the color sort of helps dictate how common those terms come up. If you look in the purple wheel, there is call, meeting tomorrow. A lot of times, tomorrow send, HRC for Hillary Rodham Clinton. That might be something you care about. So what this does, it doesn't actually review documents for you, but it helps you identify and maybe prioritize what to look at first. So you might want to spend initial attorney time on maybe that blue part of the wheel because it might be important to your investigation or your matter. And maybe it may not, but that helps you sort of not just jump right in like in the olden days. In my prior example, we had a bunch of bankers boxes, 3,000 pages in a box, and start flipping through them. This does that pre-calling for you, pre-organization for you, rather, help target your review. H5 Matter Analytics, I mentioned that earlier. Email threading is an example that can help there. It can help the whole email conversation, and it will show you all the different parts of the conversation, and even go as far as to show you if you have an email account where there were deleted parts of the conversation based on other email systems that had those conversations. You can actually see where emails went missing in someone's conversation, which might be helpful for your case. It can help find near duplicates for texts and even help identify personal data. That might be important, for example, if you have a cyber breach. Maybe you're investigating for a client which employees' files or client files were accessed by the bad guy. You might need to figure out what personal data of Jane Smith was accessed. And then based on that answer, the organization might have a duty to notify Jane Smith, who lives in Ohio, based on Ohio laws. Hey, look, Jane, on X date, you may have been compromised about this data set. So the tool can help you find that kind of data in a data set and assign it to that person, that custodian, which can be really important for those kinds of cases. Brainspace is sort of like, in a way, a relativity analytics, concept searching. And I mentioned blackout, where it can do redactions of things you don't want the other side to see. Maybe privilege, maybe it's as simple as agreed upon confidentiality terms. Maybe it's about non-relevant stuff, and most of the document is relevant, but you want to redact what isn't. So you can use that technology to help auto redact things too. There's a lot out there. I know it's a mouthful, but the takeaway really is pretty much, if you need to find information, only want to produce part of it, or if there are gaps in the data set you're trying to identify, you can use technology to help you do those things. And in terms of review methods, there's really, again, two dichotomies, two ways to go about it nowadays. The old day was linear review, which is the example I gave a few minutes ago. You just have a bunch of documents, you go at it. That's really not the way that most firms go about these projects anymore. The middle tier is assisted review by technology, or TAR 1.0. It's called different things, where in the olden days of this technology, about 10 years ago, you would have a seed set of documents, a sample set. You pull a statistical sample. You would train those documents, feed the results into the computer system. It would then give you a second seed set You do it iteratively until you figure out what your actual key terms are, and then have the technology find the rest of the documents. That's changed in the last 5 years. Now it's called continuous active learning, or TAR 2.0, where the algorithms are even stronger, they're more dynamic. So no longer do you have to actually do what are called seed sets. You train the algorithm in multiple rounds, but it learns live. So as you go through a document set, the algorithms are more stronger now that it learns your coding decisions. It feeds back things to you more quickly. You can train it faster, and you don't have to do iterative review. And I'll get to an example of that in a second. But this is the old way is sort of that middle bar, and then the newer way is the last row there. Think of it in terms of algorithms like I used this example earlier, Netflix queue. So if you like a show like Stranger Things or whatever it might be, based on your viewing preference, Netflix will recommend other shows like that one. Spotify, same thing. If you listen to certain music, it will have music from that genre. The technology does that now, but for documents. And it's a binary decision. Typically, it's responsive or not, or hot doc or not. But it then uses those decisions that you make as an expert in the case to go look for similar concepts throughout the rest of the corpus that's not yet reviewed. That's the best I can explain it in non-technical terms. Okay, so what's a use case for this stuff? This came from an actual case we had a couple years ago. A client had a subpoena to respond to. It's a DOJ subpoena, so it was pretty high pressure, pretty quick turnaround time. And the original document collection, after applying to some basic key terms, returned 34,000 documents. That's not huge in today's parlance, but still pretty big in a short-term time frame, smaller company. And so they had 10, 15 boxes to get through in old school terms in a short time. So what we did, we took a random sample of those documents, 10% random sample, which you can use these tools to take a statistically valid sample, and pull in the 10%, pull in that sample, only 10% of the documents in that collection were deemed to be relevant. So what that would mean is you'd have to review 10 documents out of 34,000 if every 10 documents had one relevant hit. Obviously, under Rule 26, for example, proportionality, that's not the best way to go about it. It's not the best way to go about it even substantively, because you're reviewing 90% junk. So how do we solve this problem? We know that through the keywords, they weren't probably that refined, return lots of junk. How do I find what truly is responsive to the DOJ subpoena so I can respond in a reasonable fashion and get government off our back? So we use continuous active learning. So as I mentioned in my prior comments, what it did was in the tool, started learning the reviewers' relevance decisions right away. So we started down the path. Only after 500 documents, we started pulling the sample, and of the 500 documents, the percentage of relevant hits, because the algorithm would feed back to you more documents to look at after you reviewed a single document, would give you more to look at. The relevance hits went from 10% to 43% to 83% after only reviewing 2,000 documents, which is less than a banker's box. So what it did was it front loaded in that review the real stuff the attorneys needed to see. So, and as you know from the federal rules, they don't require perfection. You're not going to find every document in the haystack anyway. There are studies out there that show that manual review using no technology returns between, at best, 80% of what you're looking for, and at worst, 20%. So after really looking at one box of documents using the technology, they were coming up with over 80% responsiveness. And so ignoring basically the chaff from the wheat, so to speak, using the active learning tool. Here's a graphical depiction of that. So day one, or day 1 and 2, actually, they weren't in the tool. This is common as well. We get called upon for an emergency, we get the database set up, and then the lawyers don't call us back for a couple of days. But once they get into it, day 1's 10%, day 1 of the actual review, which is not good. And then by day 8, 5 days later, they're 83.5%, looking at a very small data set. And what that tells you is you can actually then, once you think you're nearing the end, you can do what's called an illusion test. And what an illusion test does is it goes back into the remaining corpus not yet reviewed. It'll pull a sample and it will tell you, based on your historical tagging and the responsiveness rate to date, I'll make the numbers up, say there are 20,000 documents remaining. If you would look at every single document going forward with this illusion test, you might find 8 that are responsive. It'll have that level of granularity. So you can decide as a legal team, do I really want to go through the rest of these documents? Can I just stop and tell the other side, here's your data set and just stop? Because you have that backup, say why you stopped. And again, from my prior comments, that's where Rule 26 comes in. Using technology, you read most of it, you found 85% of what likely responsiveness in the data set, you have the backup and the math to show you that's the case. And so in this case, it was a big success where the client got through that corpus pretty quickly, didn't need to review a lot of that data, did it in a cost-effective manner, and most importantly for the client, met the government's deadline. There's other examples we can walk through. We have limited time today. We have this where there's millions of pages, same technology. This is relatively small, important, but it goes to show you the tool is pretty broad and can be used in many different circumstances. So what do courts say about this technology? I've given many presentations on this topic, and I invariably get the question, I feel more comfortable having a machine or a computer tell me I could stop review. And it's pretty settled law going back 10 years now that using technology under certain circumstances is okay. So the first court that really looked at this in any serious way was in 2012 in the Southern District of New York. It was a discrimination case against a large advertising firm. The defendant had lots of AI to look at, not unlike my client that had the DOJ subpoena to respond to. They wanted to use technology to leverage technology to go through the corpus. And the plaintiff objected, said, no, we're going to put paint on you. You have to look at every file. It is what it is. That's how discovery works. And the court there said, in an opinion, that, again, statistics show that computerized searches are at least as accurate, if not more so, than manual review. And so using technology is an okay thing to do. And while it's not perfect, the federal rules don't require perfection. I don't think any other court rules require perfection either. So in terms of the just, speedy, efficient administration of justice, that whole concept, proportionality, another concept, and not spending too much time going after junk evidence, the court here said it's okay to use technology, and it was decided in this opinion that that was appropriate. A few months later, another case, there was 250 gigabytes of ESI to review in commercial litigation. The defendants were permitted to use predictive coding over plaintiff's objections. This technology, I believe, was that first iteration I mentioned where you train seed sets and had iterative review and then use the technology, but still it was the early adoption of that technology. And the court observed that analytics is capable of locating upwards of 75% of potentially relevant documents at a fraction of the cost and a fraction of the time of linear review. So I used my example earlier where in the subpoena example I gave, it was 83.5% relevant, which is pretty darn good. Here we have a court saying that 75% is pretty darn good too, and looking at proportionality and having a lawyer spend hours and hours of time and the client spending hours and thousands of dollars reviewing documents, enough's enough. And so this is an example piggybacking on DeSilva Moore permitting that technology, again, going about 10 years. 2 years later, there was a discovery order by a magistrate that allowed one party to use defendant to use predictive coding over the plaintiff's objection. There was a motion to reconsider that decision, and the district court denied that request. So it basically adopted the discovery magistrate's permission of using technology. Literature the court reviewed indicated predictive coding had a better track record in production of information than manual review or human review, and you can't expect perfection. All you can expect is good faith, committed to produce responsive documents. When you think about it, going back to my earlier example of we practiced law years ago, you're in a warehouse or in a storage room with 15 other lawyers. You're going through documents, Jones a day, it was 15 hours a day, for hours and hours. That couldn't have been as accurate as what machines do now. I mean, I'm sure that I coded one document as responsive at 8 a.m. and by 8 p.m., a very similar document was either not sure, privileged, or non-responsive. So the technology probably net is better at the end of the day, as long as you train it properly. And it wasn't foolproof to begin with. So the courts are catching on to that. Again, this goes back now 8 or 9 years that it's okay to use this technology. Fast forward even more recently, a couple of years ago, commercial litigation involving Southwest, they want to use keyword searching to start and then using that to do technology such as review. In relation to human review, does not offend the court's expectation of reasonable cooperation and discovery. Just another moniker that it's okay to use this. This is in California. The first two cases were on the East Coast. And then closer to home, it's down the street here in Pittsburgh. This was a litigation that I actually got involved in before I left Covestro. I'd like to see it through. It's an interesting case. It was a price fixing class action involving Covestro and several of its other manufacturers of polyurethanes. The allegation was they colluded to fix prices. and to limit supply and to limit production capacity, to charge more for chemicals. And so in that case, as you can imagine, there was tons of ESI to review. This all happened after I left. I had no hand in this decision or this process. It just got started before I left. But there, the defendants wanted to use a certain methodology. The plaintiffs had an opposing methodology. So unlike in the prior cases where the plaintiffs just objected, in this case, the action experts say, you can use the technology, but use this methodology. And they identified a different method than the defendants wanted to use. At the end of the day, what the special master there said was, most importantly, is to work with one another and be transparent. They didn't adopt the plaintiff's method or the defendant's method, but here said that cooperate and get along like adults. And I think the takeaway here is it's a foregone conclusion in 2021 that technology can be used. It's how you use it. So I think the discussion has shifted away from, is it okay if I don't look at every file, towards when I use technology, how do I go about the methodology to use it, the program I'm using, maybe the tool, what's my method in doing so? So it's definitely a balancing act. To me, as a lawyer, we don't give legal advice from my firm. That's a caveat, which is true. But if asked off the record, I think it's work product. If you decide to use technology, how you code it and how you decide to use the keywords and what keywords you pick. But if you want to use it, some courts have said be transparent about it. So that's another practice consideration. If you want to use continuous active learning tools like the ones I mentioned, just be prepared. You might have to be involved in an ongoing discussion with the other side over how you go about doing it. But that might beat spending 25 times more hours going through all the files, especially because companies nowadays are more aware of this technology. I think long gone are the days where they agree to just hire a bunch of associates to sit in a conference room, review documents for hours on end. They know the tech's out there when you use it responsibly. So just keep that in mind, how transparent you want to be and how cooperative you need to be. I know it's not an easy decision, but sometimes courts will ask that you cooperate with the other side when using this technology. So I want to pause there. I'll leave 5 or 10 minutes for questions and feedback for the team. But so to recap sort of the key takeaways here, if you take away maybe 3 things from today's presentation, it's that data mapping really is important. It's not just the records manager job or the IT person's job, to do it often and early with your clients. Second thing would be when you're collecting things, make sure you have a plan in place to get it defensively. There are different levels of access and different licenses out there and collecting different data sources. Just have that discussion about how to go get information in a responsible way. And the third takeaway from my perspective is technology can help you get through this stuff. So even if you collect a lot of data, you're giving budgets to your end client about what's going to cost to go through all this stuff, keep in mind there's technology that can help you with that. It doesn't need to be, well, there's 1,000 documents and it, X documents an hour, X hourly rate, here's your cost. There's technology can help reduce that number exponentially to get things more efficiently and sometimes, frankly, better and more accurately. Yes. Yes. Any other questions? I'll check the chat one last time here. One question here. So, what is the best way to ensure that opposing counsel has turned over all relevant emails in a keyword search without having a third party conduct the search? So there's a couple ways you can do that. I'm assuming in this instance, you're going to actually have the corpus of emails that they produced. You can do some sampling of the set that you received. So you can go through that set and see if there's missing gaps, for example. You can actually ask them in spirit of cooperation to, they might not want to do this, but want to double check that is to turn over any error rate logs that came during their sampling process. But the most non-objectionable way is to, in the set that you get, you can run analytics on that set to see if there's missing gaps in the conversations or missing terms in the conversations. That's a good question. Excellent question. Another one coming in. Oh, okay, thanks very much. And then the last thought I'll leave you with is in terms of going and getting the data and capturing it appropriately. We hear many, many times, this is the practice pointer, the client will say, don't worry about collecting data, our IT, in-house IT can do that. And a lot of lawyers, rightfully so, take their client's word for it. I would ask that next question to have a conversation for the following reasons. There are many cases, for example, with Microsoft Exchange, the standard Microsoft license that most companies have, and this isn't known to many people, the eDiscovery license, if you apply key terms through a data set, maybe it's an email account or a SharePoint site or a Teams site, the standard Microsoft eDiscovery license will not find key terms in PDFs or zip files. It skips those file types. So what that means is if you apply at collection those key terms using a standard license, you might miss a lot of files that would have otherwise hit on those terms. And so the way to do that is to either get an improved higher level license, and they're out there, or to have the entire email account collected and apply those key terms at the processing phase I mentioned earlier in my discussion, whereby you actually then unzip the zip files. You apply what's called optical character recognition, or OCR, to the PDFs to make them readable. That's a common mistake we see clients make. They'll give us a data set and it's clear that they under collected, but it's because the Microsoft license they have wasn't sort of an advanced eDiscovery license. It's a basic license. That's one watch out there. And on the cell phone front, keep in mind that if a lot of folks say they deleted text off their phone and you want to get the text off their phone, don't bother calling Verizon or AT&T for iOS messages. They won't have them. The iOS messages, what we call text messages, are on a database on the actual device. They're not the cell phone carrier. And so a lot of people will wait and say, oh, I'll just subpoena Verizon for that. And then that evidence goes missing. Verizon will have call log information, cell tower pings, maybe metadata a text was sent. But in terms of iOS messages, for example, those are on a database on the actual phone, not in the carrier's sort of network. So just some common watch outs. Things like that might seem like a big deal. And then you looking 2 months later for a text conversation, or maybe in the prior example through emails, and there's missing terms. Those could be things to think about. So I like to end my conversation with a couple takeaways there from a collection standpoint. It might think hyper-technical, and it kind of is, but it's also something just to be aware of. So if you want the microphone back there, Lori, and any final words for the team?
Thank you so much, John. What an informative, makes you think.
Yeah, there's a lot to learn.
Even as a tech user, how much is out there and is available to people if you're not careful. Again, I just want to say, if you want CLE credit for this class, you could call 412-350-5353. You may ask for me if you wish, Lori Hagan. And we'll take payment over the phone, and I'll make sure that you get the CLE credit, because I can turn in the roster sheet as soon as I hear from everyone. So we will be having more CLEs. John has a couple more that we're hoping to put together. He has already. We just have to pick dates and times. Probably at least one this fall, if not two. And looking forward to that. And looking forward to seeing you again. Thank you so much for your time. One of the things that I told John today too was I take a look to see through the materials that we have here in the library. The latest book, we have a couple books here. There's Pennsylvania eDiscovery. It's from 2017. If there's a newer one, guess who's going to be looking to see if there is one. And we also have the electronic discovery desk book that's done by Practicing Law Institute. We have the 3rd edition, which was 2019. We might take a look and see if there's a more current version of this, since and there are a lot of CLE books on this topic, very basic ones too. So if you need to step back a little bit further from what John has started with today, that might get you started as well. So just want you to know that we're a resource for you. Go ahead,
And
John.
one other thing to close as well, if you ever have a question about technical topic in one of your cases or investigations, just call me. I mean, we give, quote unquote, free counseling consulting all the time to folks in Pittsburgh. Our home is here in the Frick building. We were founded in 2007, as I mentioned. I think I mentioned that. Call Pittsburgh our home. Love to help attorneys locally. So anytime there's a question, something didn't feel right, maybe your adversary is telling you you should be your left and you want to be a right, you're a client, you just call me. My number's on the screen and happy to talk you through it. No problem at all there.
Wonderful.
Yeah.
Thank you so much, John.
Sure. Thank you.
All right. Thank you for participating and hope to see you again soon. Thank you. Bye-bye.